Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey guys, let's go back in our time machine to the summer of 2022, kind of late June. Bruen came out. We really thought that that was going to significantly change the world, that the sun was going to rise again, that all of these crazy gun laws would have to go by the wayside. I mean, the only way to work around Bruen would be to just flat out ignore Bruen. Not like that would ever happen, except, well, here we are again talking about a court that just flat out is ignoring the law. And ultimately, that is going to be the method by which these civilian disarmament courts are going to uphold these gun laws. They are simply going to ignore the law. I will give you an example today. It's a case that doesn't involve firearms. It actually involves stun guns, tasers, whatever you want to call them. But it really goes to show just how disingenuous courts can be when they have a desired result in mind. So today, let's spend a few minutes and let's talk about the lies that courts will tell to disarm you. So today we want to check out and see how secure StopBox really is. So we're heading over to one of the book clubs to have it tested by one of the most dangerous creatures known to man. That's right. I'm talking about the drunk suburban housewife.
You guys, your name is Mud.
Oh, hey, ladies.
Oh, hey!
How's book club going?
Oh yeah, I have a shit ton of stuff.
You look like a Lolita.
No.
Lolita.
What is wrong with me?
Call me Steve, Jake. Ew. You look like a Hannah
Taylor. No.
Yes.
No.
Yeah, with those lips, you're
100%
Lolita. Spicy.
Yeah.
Cumin.
Sorry.
Okay, ladies, got a little challenge for you here.
Oh.
Yeah. Okay, so listen, here's what I got. I got a $200 spa package to Willow's Lodge.
Ooh la la.
I got 2 days, 2 nights at Suncadia, $100 at Target,
Nice.
and $100 at Wine and More, because I know you can need that. So, any of you get into the box, it's yours. Have fun.
Okay, who wants to go first?
I can get in
Okay,
the box.
Beth. Get it, girl. Get it, girl. Come on. Get that spa package.
Oh! Yeah.
Come on. Ooh. Get it. Come on.
You gotta push all the buttons. You do the same thing over.
Come on. You have to figure this out. I just give up. I'm pouring more wine.
Give up?
Yeah. I give up.
All right, well,
You didn't pour me any.
close, but looks like they're all mine. Thank you, ladies.
What?
StopBox. Protect your family while protecting your family.
Bill, we need more wine.
Yeah! Woo!
Okay, America, we're going to talk about a case out of the state of New York. It is a challenge to their prohibitions on stun guns, tasers, whatever you may want to call them. The case is called Calce versus New York City. Now, I may be pronouncing the defendant's last name wrong, and if I am, I apologize. It is a case that's brought to us by our good friends over at the Second Amendment Foundation, as well as the Firearms Policy Coalition, which of course means there are links below in the description box so that you can show them some love. Now, as I mentioned, a challenge to New York's outright ban on stun guns. And you're sitting there going, well, wait a second, wasn't there a Supreme Court case that talked about that? Yeah, actually there was. It was called Catano v. Massachusetts. And many of you are sitting there going, well, didn't the Supreme Court find that stun guns were in common use and therefore cannot be banned? Yeah, they did. Sort of. I think you need to understand what really happened in Catano. Catano was not a published opinion. Catano was a per curiam decision, which means that basically all 9 justices just agreed, and there was a very brief order and ruling handed down by the court, which typically does not even have an author attached to it. Now, in the matter of Catano, Justice Alito, who was joined by Justice Thomas, they decided to author a concurring opinion. And in that concurring opinion, they talked about the popularity of the stun gun and made the statement that these are obviously in common use for lawful purposes. So when we sit there and we go, well, hey, the numbers established in Catano actually established the baseline for in common use, it's a good argument, but there's an argument that can be made on the other side that it didn't really have that type of constitutional mandate. Now, this is on a cross motion for summary judgment. So the plaintiffs are saying, hey, the law is so unconstitutional, we should just win right now. And then, of course, New York City is saying, hey, there's nothing wrong with this law at all, and this lawsuit should be thrown out immediately. The court has sided with New York City, okay? Shocker. That's probably why we're doing a video on it, right? So they have said that, hey, listen, even though I get that there were Supreme Court justices in Catano v. Massachusetts, and they found that stun guns were in common use and therefore protected by the Second Amendment and therefore cannot be banned, we get that. But we don't believe that to be authority. We'll go through that right here. And ultimately, and this is what the court has found, is that the Second Amendment offers no protection to stun guns whatsoever. That stun guns, tasers, and all that do not fall under the purview of the Second Amendment. And they've done so by bastardizing the Bruen test. Okay, now let's talk about how the court bastardized the Bruen test to make sure they got to the wrong conclusion. We know, if you just take a look at the plain language of Bruen, that the first step of the inquiry is a simple one. Does the plain text of the Second Amendment cover the activity? In this case, it would be, does it bar the possession of an arm? The answer is yes. If the answer is yes, the burden then shifts to the government, in which they must justify it through historical analogs. When we get to outright bans of most items, we don't need to do a historical analysis. It's been done for us. It's already been done. So I get that there may be some more novel concepts, there may be some more esoteric gun laws where we're going to have to actually do a historical analysis as to the how and the why, but it's been done already, and it's called in common use. Because if an arm or a weapon is in common use for any purpose, any lawful purpose, including self-defense, then it may not be banned. And the test is that simple. But what the court is doing is, rather than saying, hey, it's a text analysis followed by a historical justification, what they're saying is, to establish the requirements under the text analysis, the plaintiffs must also prove that it is in common use for lawful purposes. And so it's all encapsulated into the first part of the test, which means that would also allow the court to engage in its own independent historical analysis. But you see, they never had to go there, because they find that the stun gun is not in common use for lawful purposes. It is not, therefore, protected by the Second Amendment, and there is no further inquiry. Therefore, because determining which arms the amendment covers is a textual matter, the common use analysis is to be conducted at step 1, in assessing whether the regulated conduct is presumptively protected by the Constitution. So you see where they absolutely got it wrong right there at step 1. And then at least they're honest enough to say, hey, the reason we're doing it is because if it's just going to be about simple numerical value, well, then we can't uphold these bans. Because the very next sentence that the court wrote was, plaintiff's contrary narrow interpretation of the textual analysis that step 1 is quickly and conclusively satisfied because stun guns and tasers plainly qualify as arms is too facile and would essentially eliminate the step 1 analysis whenever a regulation has the slightest connection to guns. Okay, so with that in mind, then the court in New York rules, according to Bruen, a plaintiff must prove that the regulated weapons are in common use in order to qualify for the presumptive protection under the Second Amendment. So once again, you can see where they're taking the historical analysis and they're moving it over from step 2 into step 1 and saying, if you don't establish all of this, well, then the plain text of the Second Amendment does not apply. Oh, and the authority that they use to justify this is a case out of the Ninth Circuit, never a good thing, and then Rahimi from the Fifth Circuit. And Rahimi is apples to oranges, because we are talking about banning people in Rahimi, and here we are talking about banning things. And so even though the Supreme Court, way back in 2016, had no problem finding that stun guns were in common use, the court in New York finds plaintiffs do not even identify the most basic of statistics, including, for example, the number of stun guns and or tasers purchased in the United States for any given year. Thus, plaintiffs provide no evidence whatsoever to support their claim that stun guns and tasers are in common use in the United States for self-defense, let alone in New York City. So it's in common use for self-defense, and in the eyes of this court, it's in common use for self-defense inside the city limits of New York. That's actually the test that they announced. Now you're sitting there going, hey, how do they work around Catano? How do they actually, what kind of mental gymnastics did they pull here? They didn't really pull mental gymnastics. They basically just threw a middle finger at Catano and said, it's not good precedent. I'm not joking. This is what the court wrote. Plaintiffs also overstate the Supreme Court's holding in Catano v. Massachusetts, arguing that the case erases any conceivable doubt concerning the weapons at issue. In Catano, the court vacated a Massachusetts court's judgment upholding a ban on the possession of stun guns, but it did so specifically because the explanation of the Massachusetts court offered for upholding the law contradicted the court's precedent. The Catano court did not, however, conclusively determine, because it was not required to, that stun guns and tasers are in common use. But understand that the very reason that the United States Supreme Court unanimously believed that the Second Amendment protected stun guns is because they were bearable arms, and the reason they could not be banned is because they were in common use. So that is the exact reasoning that the court used, and they did that reasoning actually with the old two-part balancing test and still got to the correct conclusion. But here, a court in New York, hell-bent on upholding this law because this is New York State, this is New York City, they've never met a gun law that they just don't absolutely adore. Not only are they willing to bastardize the test, they're actually willing to just flat out ignore Supreme Court precedent. Okay, the case once again is Calce versus City of New York. We're going to link it up down below so that you guys can geek out on it for yourself. Don't have to take our word for it. Remember, there are links down there for Gun Owners of America and the Firearms Policy Coalition who brought this fight to us. If you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all of that's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.